Court rise. The application in the matter of the Queen on the application of Harry Miller and the College of Policing, the Chief Constable of Humberside, part heard.
My ladies, my lord, we left yesterday with the final ground of appeal to be considered, that of proportionality, and the errors that we say the court made below. But just before I turn to that, one point of clarification that arose overnight, having taken instructions, and it arises from questions from the bench. The court will see that what the objection here by my client to is having a non-crime hate incident recorded against him. And as we said in submissions, that implies judgment and gives an official imprimatur to the allegation of a hate crime, a non-crime hate incident having been committed. We drew the distinction between information collected by police forces that are objective and the information in the current circumstances. What that means, however, though, is that it wouldn't be objectionable, if that analysis is correct, for the police to record that a complaint was made that a non-crime hate incident had taken place. My client is quite clear that he wouldn't find that objectionable. The mere fact that a complaint has been made is of limited significance, far less significance than the complaint having been recorded as if it's a fact. I just thought I'd clarify that at the outset.
How did you term that a non-crime hate complaint? What sort of terminology?
It could be categorised as that.
Well, how would you categorise it?
A complaint made. Yes, it could. Yes, I'm quite satisfied with that description, my lord. A non-crime hate complaint.
Even though, in your submission, there's no evidence of any hate element. Well,
that's a rather separate issue, my lord. But the primary point is that it's the recording of this was with respect. This submission was with respect to the recording, and your lordship asked the question about how does the police cope with the information that it's got? How does it categorise it? What does it do with it?
And it's either a complaint or an incident or a crime in terms of gradations. Is that the right analysis?
Well, there could be a complaint of an incident or a complaint of a crime. But in fact, if memory serves me correctly, the complaint here wasn't of an incident or a crime, it was just a complaint in general terms. And in practicality, one would anticipate that would be the usual case. I haven't given much thought to the actual way that it's recorded. I was just drawing attention to the distinction and the objection, the primary objection being to the recording of a hate crime incident rather than a complaint of a hate crime incident.
But I thought the manner of its recording was one of the central complaints.
Yes,
by
absolutely,
your client.
Absolutely, my lord. Yes, but it's what's recorded as well. It's an objective fact that Mrs. B made a complaint in respect of my client, just as it's an objective fact that Mr. X may well have been sitting in a car outside 23 Acacia Drive at 1:30 on a Friday morning, which is legitimate information for the police to court what is not an objective fact, that my client had committed a non-crime hate incident.
Or that there had been.
Or that there had been, probably better.
Whether there had been.
Yes. Yes.
Thank you.
Hopefully that's helpful for the court. If we now turn then to deal with proportionality. The first point which we deal with very briefly is the correct approach on appeal in proportionality cases. And my learned friend, our case, that it's necessary to establish a significant error of principle on appeal in proportionality cases. And of course that is correct. That's what Lord Cornwall said, and we do say that there are significant errors of principle in the approach of the judge below in this case. However, I would draw the court's attention to an analysis, a recent analysis by Lord Sales in a speech that he gave, which we've got in the papers. I'm not going to take the court to it at the moment, but it's in the papers for the court if they wish to look at it. It's Authorities Bundle 48, right at the back of the bundle. I can see my pulling it up so we can perhaps do so. I've got a page to hand. Page 185.
Again, Mr. Wise, we have to look at what we've got observations in the Supreme Court, then that is the right place to.
Yes, well, what Lord Sales does, he analyses some of the Supreme Court cases, including Nicholson and some of the welfare.
If you want to adopt that analysis and put it forward on behalf of the.
Well, we say that is the correct approach in this case, but in substance it will make no difference because we do say that there's significant errors of law. But what Lord Sales does in his speech, he analyses a whole series of Supreme Court cases and shows that in practice what the appellate courts, this court and the Supreme Court have done, in those cases with wider import, have actually done the proportionality exercise for themselves, rather than the more light touch approach that the courts have adopted, where the impugned decision is of a more limited nature, typically concerning an individual. If it's systemic or as in the case of Nicholson, life and death, then I think Lord Sales refers to the benefit of the wisdom of the more senior judge. I forget exactly the phrase he uses, but you get the sense. And he says that's something that counsel should be. His concluding sentence, I think it is. It says that counsel should be prepared to deal with that in any appellate proportionality appeal case involving proportionality. So we just make that broad point to start with, that the courts in cases such as this should take a hands-on approach rather than a hands-off approach, I think is perhaps a shorthand way of putting it. But in any event, as we say that there were significant errors in the approach of the judge in this case. We've set out in the skeleton argument the 6 errors that we say that the judge made. There's a preliminary remark before we come to those. The court will have seen in the analysis of the judge below, he begins by referring to the run of cases that refer to unacceptable risk of unlawfulness, Sophia, Woodcock, and I think it's BF, the other case. We would say that's an inapt approach to convention cases. That's a common law principle, that of unacceptable risk of unlawfulness, and it isn't the test that's been applied. And indeed it's circular, because we say that the policy here is unlawful per se, and one doesn't have to establish a number of unlawful decisions to show that the policy is disproportionate.
So it wasn't your case below that the policy was unlawful because it gave rise inherently to a risk of unlawful decisions?
Well, that was inherent in the submissions, but that wasn't the way that we put it.
That's not the way you put it.
That wasn't the way we put it. But that is part of the proportionality analysis, ultimately the fair balance analysis. there's a risk of unlawfulness. But that's just one of a number of factors that goes into the melting pot in the analysis, Malady. So the first error that we identify, this is in the skeleton argument at paragraph 50, subparagraph A, is that the judge proceeded on a wrong starting point. Namely, he says on a number of occasions that the level of interference to freedom of expression is low. But that conflates, or perhaps confuses, the test for interference, which, as we explained and considered yesterday, is a low test, with what the actual impact of this policy is. Those are two quite separate things. And so when one looks at what actually happened in this case, looking particularly at my client's evidence, his wife's evidence, and more generally, we see that it's a very profound impact on freedom of speech. And what we say by the judge starting at the presumption that there's a low level of interference with freedom of expression, that what he's done there is impermissibly minimise the impact of the guidance on the value of freedom of speech in a democracy.
Well,
in the same way, sorry.
There are 2 points which I think you need to separate out. The first is whether he's confusing, as he's put it, the test for interference with what the actual impact of the policy is. And the second is the fact that you don't agree that the level of interference is
low.
As the judge characterised it, but those are 2 separate points.
Yes. Well, it may be that he conflated the two. It's not entirely clear from the judgment. But in any event, the evidence demonstrates that the interference isn't low in this case.
But what's the? I mean, that's an evaluative judgment by the judge, and it may be that he thought and concluded that given all that happens here, and I'm not seeking to minimise it, is recording without more or without necessarily any more, that is a low level of interference as compared with, say, cases where there is the potential for a criminal investigation or the banning of a book or...
But he doesn't say that, Milady. He doesn't rationalise it. And
that's a reasons challenge. What you're challenging is his evaluative judgment, and you've got... I mean, that's difficult to do on an error of law basis, isn't it?
Well, we say not in this context, Milady, because of this particular importance that freedom of expression attracts.
Well, that's a different point. This is about the level of interference. The judge is saying it's a low level of interference, so when I carry out the balancing exercise, I weigh on the one hand a low level of interference, and on the other hand the benefits of the policy.
We say, taking on board your lady's point, we say that he was wrong to find there was a low level of interference.
Can you just actually, before you carry on, show us the parts of the judgment you're challenging?
Paragraph 226. There says, overall, I am satisfied that the aims and objectives of HCOG justify the limitations it imposes on freedom of speech. That is because its aims are extremely important for the reasons I have given. As against that, the level of interference to freedom of expression is low. But he doesn't say why. And as we identified yesterday, the reason why a significant factor in his reasoning for finding there was an unlawful interference by the police force that he sets out at paragraph 257, based on my client's witness statement, is with regards to the recording, not the actions, recording as per the policy rather than the actions of the local police force. So we say that by characterising the interference as low, the judge was wrong, failed to have proper regard to all the relevant evidence. And so inevitably, when one's coming to do the balancing exercise between the rights of the citizens and the rights of society more generally, he starts from the wrong position. And that infects the whole exercise in our submission.
Does the judge discuss anywhere the potential for the data to be unearthed years later and used in relation to somebody's job application?
He does somewhere, my lord, if you just bear with me one moment. Not sure whether it's in this section or whether it's with respect to the release. 181 of those defence tells me.
Yes.
Oh yes, I'm ready.
Yeah.
I'm ready for that. And 182 as well, of course. 181 has two paragraphs. The second point we make on proportionality, that in considering the factors weighing in the proportionality balance, the judge overlooked the fact that as he recognises with respect to the second defendant below, there is little scope under Article 10.2 of the Convention for restrictions on political speech and the on debates of questions of public interest. We see that at paragraph 252. He quotes there from the 9900 case. I don't think it's a controversial statement. Given that there is such little scope, that is an important factor that goes into the proportionality balance, which the judge doesn't recognise. If we can then return to paragraph we were looking at a few moments ago, 226. You'll see that the judge then considers the role of the courts and the application of Article 10 with respect to what he describes as genuinely hateful speech.
Sorry, Mr. Wise, I'm lost. Where? Which
226.
226. Thank you. Sorry.
And you'll see, if we go five lines from the bottom, where Article 10 is not excluded by Article 17, pausing there, Article 17 being a catch-all provision in the Convention that the court may be aware of. So there isn't protection for people who are acting in a genuinely hateful way. We're not in Article 17 territory, and never have been. So where Article 10 is not excluded by Article 17, then any restriction upon genuinely hateful speech has generally been easy to justify as necessary in a democratic society than other forms of speech. But that, we say, is totally irrelevant to this case, because as we've seen, what happened in this case, the judge was that the judge found that there wasn't any hateful speech here. So, in that respect, it appears that the judge took an irrelevant factor into account, into the balancing exercise. The fourth error, we say, arises from paragraph 228, page 119 in my version of the full bundle, with respect to less intrusive measures. Of course, there the judge didn't consider any less intrusive measures.
Just as a matter of interest, not because you were required to, did you suggest less intrusive measures?
I think not, my lady, no.
Right.
But in any event, it was incumbent upon the judge, when he was dealing with that issue, despite the fact that he wasn't invited to consider it for himself.
Yes, and it's not for you to identify them, but it's sometimes helpful.
Yeah, absolutely. And there will be cases when just a counsel would. My junior's just checking behind me, Melinda, but my recollection is that he didn't. And we suggested one less intrusive measure this morning.
Well, another might be not to use the name of an individual concerned. For example, if it's important to have recording of incidents for the purposes of measuring various matters which have been identified by the respondent.
Just picking that point up, it's a very good point my lady makes. There's two purported justifications for the policy. One is to stop incidents escalating into more serious crimes and so forth, the sort that a civilian person was considering. And the secondly is with respect to community tensions. Well, both of which are legitimate aims. We're quite clear about that. But if one looks at community tensions, then anonymisation wouldn't make a jot of difference. So we say that the judge was wrong in that respect also. That's D in paragraph 50 of the skeleton arguments. The fourth error we say that the judge made. Fifthly, the court has what we say there at subparagraph E. None of the evidence relied on by the judge related to, let alone demonstrated, the necessity of recording of the recording of legitimate matters of public debate. And we also refer there in the general consideration of the evidence, failure to have regard or proper regard to the dangers outlined by Sir Richard Henriques. That was brought specifically to the judge's attention, and the dangers of police uncritically recording complaints made. The court was taken to that yesterday. I don't think I need to take you to it again. And then finally, safeguards were referred to as being relevant in the proportionality balance. But none of the safeguards, in truth, do protect the freedom of expression in this case. In any event, the obvious point that needs very careful analysis is that any safeguard relied upon has to be an effective safeguard. Now, the court was taken yesterday to the Turkish case. Albeit that they were dealing with this under the rubric of prescribed by law rather than proportionality, the point is similar. And just invite the court to go back to that judgment. This time at paragraphs 76 and 77. And you'll see from that despite the safeguards that were relied on by the Turkish government in that case, but the court found C-77, in the court's opinion, the measures adopted by the government to prevent largely arbitrary or unjustified prosecutions under Article 301 do not seem to provide sufficient safeguards. It transpires from the evidence that there was still a significant number of investigations, etc. Well, we know from our case that there wasn't any sufficient or effective safeguards for my client in this case. He made the complaints, went through the complaints procedure. It was investigated by the senior officers at the Humberside police force to no avail whatsoever. And in any event, any safeguards such as the Data Protection Act are irrelevant when the subject doesn't even know about the recording, as we identified yesterday. The fact that the policy permits recording does of itself have a chilling effect. None of the purported safeguards have any impact on that at all. And even put at its very highest, if there was a case where an individual brought a complaint under the Data Protection Act, that would be after the event. The incident would have already been recorded. And so in summary on safeguards, we say that none of the safeguards relied on by the respondent prevent the chilling effect of recording non-crime hate incidents.
The evidence that was put in included that from the on the respondent side, that in the opinion of one of the witnesses, it would be wouldn't be a case where the information that had been recorded in the appellant's case would ever appear on an enhanced criminal record check.
That was the subject of some debate in the court below, my lady, and your ladyship sees the finding that the judge made. I think it was paragraph 187. We looked at it a few moments ago. Just let me check that. Yes, it was 182, sorry.
82.
And we finished the point by reference to my client's case. None of the safeguards provided him with any satisfaction. We know that even despite succeeding in his judicial review with respect to to what happened in his case, he still has this non-crime hate incident recorded against him. And just to clarify that, a point that arose from a comment from my Lady Justice Simler.
Yes, I've looked at the end of the judgment. The judge deals with the recording.
And it's also in the order itself.
Oh, it's in the in the order.
I was just
I'm
going
so
to take
sorry.
you to that. That's fine. Page 66 in my bond. I think the court might have moved one page out from line 67, thereabouts. So you'll see, this is the second page of the order, clause 4, the decree was made. And then under D, you'll see for the avoidance of doubt, the mere recording by the second defendant of the claimant's tweet of itself pursuant to hate conduct did not violate Article 10 of the Convention. On to make a mandatory order to amend the record.
I think the judge expressed considerable doubts about whether it should have been recorded and whether actually it fell within 2.1.4.
Yes, he did, my lady, but nevertheless,
yeah.
you'll see the terms of the final order. considering that doubt, he nevertheless remained of that view. So just to summarise on proportionality, we say the judge made a number of errors in his reading, significant errors, which on any reading we say justify the intervention of this court, whether on a light touch or a more intrusive basis, and simply got the balance wrong by not appreciating the significance of the chilling effect on freedom of expression of my client and others in a similar way, similar situation, in the context of there having to be very strong and compelling justification for interference in freedom of expression, particularly in areas of controversial political debate. I said I'd be half an hour, I think, or 20 minutes to half an hour. I think that's about it. I don't know if there's anything else I can assist the court on. If you just bear with... Sorry, my lord.
Junior first.
My duty is just look back at our skeleton in the High Court. We did raise the point about on Sapphire.
About?
Sorry. Oh yes, yeah. We unsurprisingly we did put the case on the basis of fair balance rather than unreasonable risk of unlawfulness.
Right.
That's what we'd expect. I apologise, my lord. I interjected.
No, not sure. You mentioned the heckler's veto
Yes.
yesterday, and the judge refers to that in the Vaginage
Yes.
case. Is there any other case which refers to that concept?
I'm not aware of it, my lord. I mean, it's a rhetorical flourish, but
it's got a long history, I think, in states and elsewhere.
That's right. My junior reminds me. It's got a history from the United States.
Thank you.
From there, but it's all of a piece with the standards that are required in these sorts of cases.
Thank you. Yes.
Thank you, my ladies and my lord. I'd like to begin with two important points of context to focus attention on what we say are the relevant questions on this appeal. Neither are or should be controversial, but it has suited the claimant to gloss over both points to some extent and to seek to focus the attention of the court in a slightly different direction. The first point is that the claimant succeeded in his claim against the Humberside force, which arose out of their response to Ms. B's complaint after they had initially recorded the complaint and categorised it as a non-crime hate incident. Now, the conduct of the police had a number of aspects, including a visit to Mr. Miller's business premises, a threat of criminal prosecution, and even an approach to his daughter, a serving officer in the Humberside force. There has been no appeal against that aspect of the judge's decision, and we do not seek to challenge it in any way. But what is left, then, is a challenge to the guidance itself, and in particular, see the claim form to paragraph 6.3 of the guidance as being contrary to common law and an unjustified interference with Article 10 of the ECHR. That is, it is a challenge to the provision of the guidance whereby the police are instructed to categorise non-crime hate incidents. Now, the guidance is relatively short, it is pitched at a high level, and it applies across the board to hate crimes and hate incidents of all descriptions. it sits amongst a canon of related guidance, of codes of practice, and of legislation which governs the recording and retention of information by the police. And we say it is well established and not substantially disputed that where a policy document is challenged as incompatible with convention rights, that the relevant question is whether the policy is such that it creates a real risk of unlawful interference with freedom of expression in more than a minimal number of cases. Now that point has been discussed this morning, and I want to develop it a little bit. In answering that question, the question of breach of Article 10 by the policy, the particular facts of the claimant's case, so the fact that Ms. B's complaint was categorised as a non-crime hate incident and what followed thereafter, are relevant only insofar as they may be argued to illustrate the risks to which the guidance gives rise. But one must always bear in mind, we say the dictum of Lord Justice Underhill at paragraph 63 of BF Eritrea, quoted in the judgment below at paragraph 218 to 219, that a policy is not unlawful merely because there are liable to be individual mistakes or misjudgments taken on the basis of the policy, as the judge found had been the case here when the policy was applied by the Humberside force. Now, I accept that there are certain aspects of the claimant's challenge to the policy which, if they are correct, serve to invalidate the policy in any event. So, for example, the prescribed by law challenge. If the guidance is not prescribed by law, well, it doesn't matter how it falls to be applied in individual cases. It is invalid. But on proportionality, plainly the guidance is capable of being applied proportionately by the police in each and every case. But it's also capable of being applied disproportionately, as the Humberside police showed at first instance. So when it comes to proportionality, which we say is the real nub of this claim, we say the court does have to consider whether the challenge provisions of the guidance create a real risk of disproportionate interference with Article 10 rights in more than a minimal number of cases. The second point I wanted to raise by way of context is that the court...
Can I just, before we get there, can I just ask you, perhaps you could return to it at some point, obviously we have on the one hand an individual case, and on the other we have some witness evidence from the respondent about why the policy has been framed in the way that it has and the aims that it seeks to achieve. But one of those is that one of the things that is said is, in addition, that it's really not practical, I'm summarising, for the police to conduct an investigation in each and every case because of the sheer volume of incidents that there are. And what one's therefore looking at is a system which is not able to investigate this vast number of cases, if there are a vast number of cases. I don't know if we know how many there are. And I wonder how that factors into your submission that the policy is capable of being applied proportionately.
Yes.
I mean, if there's no investigation in most cases, it's simply recorded because the system can't cope for reasons we well understand, then how is proportionality to be, how are we to consider the fact that it is capable of being applied proportionally if the fact on the ground is that there isn't any investigation?
Well, let me make 2 points immediately in response to that. The first will be to show you what are the purposes of this particular part of the guidance, why it is done. And the second point will be my second point of contact, which is to focus upon what the guidance actually does, or what the challenged provisions of the guidance actually do, what their effect is, which we say, and I'll come back to this in a moment, we say that all that the guidance is to instruct police to categorise a particular recorded incident in a particular way.
With the individual as a suspect and the person who makes the complaint as a victim.
Well, I mean, the language which individual forces use in their local records is a matter for them.
Well, what do you mean by instruct then?
Well, so in terms of categorisation, what the challenged provision of the guidance does, we say, is to say to police that where a complaint is made whereby the complainant, put it more neutrally, where the complainant has complained of a motivation of hostility or prejudice, then that should be categorised as a hate incident. Now, subject to the limits of the guidance and rationality constraints and so forth, which I'll come back to, but the basic message is that where the complaint is of motivation of hostility or prejudice, that complaint, once it is recorded as an incident, that should be categorised as a hate incident. So what the guidance does is it's a categorisation exercise. It's not an instruction to record. The instruction to record is somewhere else. That's in the NSIR, which I'll show you in a moment. So Ms. B's complaint would have been recorded in any event pursuant to quite different guidance and standards. All that the guidance in this context is to say to the Humberside police, subject to the constraints I've mentioned, given that this complaint motivation or prejudice, this is prima facie, this should be categorised as a hate incident. Now,
you mentioned that other forces have ways of recording these matters. Do you know what language is used by other forces?
So we looked at yesterday at the outset the print from the Humberside police records, and you'll recall that the heading at the top of the page is of a crime report. I think it's page 221 of the supplementary bundle.
Crime report print.
Now, my clients certainly don't recommend that that's the terminology that should be used. It's a matter for local forces what they do, but it's not a consequence of the guidance or of anything else that my clients has promulgated to say that these incidents ought to be recorded in a document that is headed crime print and has the other features that this document has. I don't have other examples from other forces, but in terms of the guidance, which is what's under challenge, there's nothing in that which dictates
either the form or the labels.
Exactly.
Isn't that a problem for you? That this force has taken your guidance and produced this form?
No. Well, that's not a problem, I would say. can I make my categorization point in a little more detail, because this is really, well, one does have to remember at all stages what this paragraph 6.3 of the guidance is actually doing, and it's simply telling police to categorise a recorded incident in a particular way. So as the judge noted in paragraph 227 of his judgment, the recording of non-criminal incidents is provided for by the Home Office's National Standard for Incident Reporting, NSIR. Now you have that at page 1770 of the authorities bundle. An extract from a longer document, but this extract essentially defines an incident and an incident which should ordinarily be reported or recorded.
But that's the point, isn't it? That your guidance says recorded, and police forces would be looking at the NSIR and using this as the template.
Well, my lord, what the NSIR does is it tells Humberside Police, in this case, that when Ms B phones up and makes a complaint, somebody else phones up and makes a complaint which falls within the relatively broad definition of incident, that the police should make a record of that incident, and of course we would expect them ordinarily to do so. What they do with it thereafter, of course, is a different matter. But all that the guidance does then is, once this record is made, and the NSAR also sets out a number of different flags which the police should apply to particular incident records as appropriate. One of which is a hate incident. What the guidance is then doing is telling police when the hate incident categorisation is appropriate.
Sorry, Mr. Cottle, I thought you started your point by saying all the police have to do as a consequence of the guidance is categorise.
Yes.
They do not have to record.
Yes.
But I've just looked at 6.3, which says it must be recorded regardless, etc., etc.
Yes.
So can you just help me about that? Page A506.
Yes, well, so the obligation to record comes from the broader NSIR, and the guidance is telling police when to record it as a hate incident. If this guidance didn't exist, Ms B's complaint would still have been recorded under the NSIR, under the national standard for incident reporting. What the guidance adds is when an incident report should be flagged and categorised as a hate incident.
So how would it, just explain how it would have been recorded? What would it, if there hadn't been this guidance and Ms B made the complaint she did? What sort of form, what sort of language would have been used to record the complaint?
Well, so I mentioned a moment ago, the NSIR has within it various different flags that can be applied to categorise different incidents. without the guidance, the police would have exercised their own judgment in applying whichever flag they considered appropriate.
But it would have been recorded as a complaint, not as an objective fact that a hate incident had occurred. Is
Maybe
that fair?
that's another flaw and another misdirection. My submission in the claimant's arguments. Once you understand that the guidance is telling police to record, to categorise an incident as a hate incident based on the perception of the claimant, then it's not recording an objective fact about Mr. Miller's conduct. What it's recording is that the complaint was made and the perception of the complainant was as indicated in the guidance. That doesn't imply, contrary to my learned friend's submissions, that the police believe or have made any judgment that Mr. Miller's conduct or anybody else's conduct was actually motivated by hostility or prejudice. It is simply recording the claimant's perception in that instance.
Well, where does this leave the? After this, I think we must let you get back to your. You've diverted your course, but where does this leave the judge's findings that there would be cases which are outside the margins of rationality? In other words, you're saying, well, it's simply incident recording and no more. And all it's recording is that that's somebody's perception. But the judge, as part of his analysis, did say, well, there would be cases where it wouldn't be appropriate to record.
Yes, where it wouldn't be appropriate to flag as a hate incident.
So although you're saying the police are not making any judgment about this, I think that's the implication of what you're saying. If it's the case that there will be cases where whatever the complainant says, the police take a different view, then they are making a form of judgment, are they not, in recording it?
So Lydia, and I do need to qualify what I said. You're right to pick me up on that. The judge found, and we accept, that there are limitations and constraints on when the categorisation should be made simply on the basis of the complainant's perception. The judge referred to specific provisions of the guidance, for example 1.2.4, which is an instance of when not to record, not to categorise as a hate incident, notwithstanding the perception that's been reported. The judge also found, and we accept and don't seek to challenge, that the normal principles of public law rationality haven't been displaced by this guidance, so that the recording, the categorisation, should be premised on some rational grounds. We accept that, but so the judgment made by the police is only that the express provisions of the guidance on when not to categorise aren't satisfied, and that there is some rational basis for the perception that's been reported. But there is no judgment, and this is very important, there is no judgment that a hate incident has occurred in the sense that Mr. Miller or anybody else was motivated by hostility, was in fact motivated by hostility or prejudice towards the complainant. That is a matter which may be taken up and investigated by the police, and they may make findings about that as well.
Well, motivation is one thing, but satisfying objective criteria in relation to whether an incident is a hate incident or not, one takes it a step further, is in the criminal context is another. So, but as I said, we've diverted you off from your submission.
Well,
so.
well, I mean, I'm really on my second contextual point. What the guidance does, what the challenge provisions of the guidance do, and what the categorization means, is firstly that the incident was perceived by the complainant as being motivated by hostility or prejudice. Secondly, that the express provisions of the guidance on when not to categorise haven't been satisfied. And thirdly, that there is some rational basis for the complainant's perception. And Mr. Wise submitted this morning that he would have no complaint if all that was recorded was that a complaint of a hate incident had been made. But that is what happens. That is all that is happening here. There is no, the police are categorising based on victim perception and subject to the constraints that I've mentioned, are categorising the incident in this particular way, are recording that a complaint has been made of this type of incident.
But doesn't that diminish the utility of this, of collecting this information? What's the point of it if all you're doing is recording somebody's belief in another person's motivation without any, where does escalation come into it? Where does satisfying community anxiety? I just don't understand the utility of collecting this information if that's all it is.
Yes. Well, Milady, the utility of collecting the information is in what is done next with the information. Now, in the case of some incidents, many incidents, they will be investigated. Steps will be taken to substantiate what the complainant has said. Now, that's not all recorded incidents, but there will be steps taken, and that's part of the guidance as well. Part that's not challenged. There will also be intelligence assessments, trends analysed, work done with the information. Which could not be done, very useful work, which could not be done if the information was not recorded and the categorisation was not made in the first place.
And just looking at the crime report print, page 221, the supplementary bundle, any objective reader of this, looking at the words primary offence, hate incident, suspect, would, if it's not right, reasonably assume that the Humberside police had made a judgment that a hate incident had taken place because of the language.
My Lord, we're not on this appeal concerned with the conduct of the Humberside force. We don't condone their terminology in their print, and I entirely understand the implications which my Lord says could be drawn from it. That's not our guidance, and we don't condone it. And we're not concerned on this appeal with the precise forms and templates and wording that the police might use. What we are concerned with is the substance of recording a complaint as a hate incident based on complainant perception. that substance is achieved by the document we're looking at, but in ways that we wouldn't condone and we don't recommend.
But if that's how a reasonable police force acts, interpreting this guidance, how are members of the public going to react when they see on an enhanced criminal records check disclosure that there's been a record of a non-crime hate incident, or people who fear that there might be such a recording? If this is how the police respond to their own guidance, or your own guidance?
That it is no part, as I've said, of the guidance to instruct police to effectively to treat non-crime incidents in the same way as crime incidents, in the way that they're in the forms that are used. Now there will be other guidance in that area, but we don't condone this.
There seems to be in certain parts of the guidance, we touched on this yesterday, there seems to be, in some of the introductory parts, a sort of fairly broad brush which deals with both recording of crime. If one looks, for example, at 1.2.4, section-based recording refers to the perception of the victim or any other person. Would not be appropriate to record a crime or incident as a hate crime or hate incident if it was based on, and so on and so forth. So in certain parts of the guidance, there's the cases which are more serious because they are investigated as a crime, and cases which are non-crime hate incidents are dealt with in the same basket.
Yes, Lady, that is absolutely correct. There are the guidance does deal, and it deals in many different areas of its contents, with hate crimes and hate incidents, compendiously, in the sense that they're in the same sections. Sometimes different steps are recommended in relation to each. And of course, we are concerned with a challenge to the part of the guidance, part 6.3, which is specifically directed to hate incidents, and is a way in which the guidance does distinguish between hate incidents and hate crimes, which is section 5.
I hadn't appreciated until just now, Mr. Coppell, that 6.3 seems to mirror almost exactly the NSIR guidance at chapter 2.5, which you'll find in Authorities Bundle 41771. Did the college copy the NSIR guidance, or vice versa?
Well, 1771.
It's at the bottom of the page of 1771.
Yes.
And it says, in terms where any person, including police, report a hate crime, it must be recorded, regardless of whether or not they're a victim, whether there's any evidence. So that wording seems to be absolutely congruent with 6.3.
Yes.
Which came first, and why is that?
Well, as I understand the section that we have on 1771, that is an extract from a predecessor to the guidance that you're concerned with. So there's a sort of cross-fertilisation between the NSIR and the hate crime and hate incident guidance. This is a section of the NSIR on qualifiers, which I believe is the flags or categories that I mentioned.
There is a safeguard in it that the record must be factually accurate, easy to understand, and identify at an early stage. Risks. If you have a record that describes the complainant as a victim and the target as a suspect, is that easy to understand and factually accurate?
Well, it's directed at the police.
Yeah.
As I said, we don't recommend to the police that they record crimes and not crimes on the same form. And we're not concerned in this appeal with Humberside's practice of doing so.
So the guidance itself refers to those who are perceive themselves to be victims as
Yes.
victims.
Well, they are treated as victims for the purposes of recording a hate crime or hate incident. But what is being recorded, and what the categorization means, as I've mentioned, is that there was a perception of hostility or prejudice by the complainant, which has some rational basis, but that is it. My lady asked me about enhanced criminal records checks. There is no evidence whatsoever that a non-hate incident, either of this type or of any other type, will appear either routinely or indeed at all on an enhanced criminal records check, merely on account of being categorised as such. Of course, if it's investigated, if findings are made, then the position may be different.
But it would be disclosed on a search.
Sorry?
On a search of the computer against the person's name, it would be disclosable.
So, how it works? And I was asked this question yesterday by my. A record of a non-crime hate incident will appear on local police information on a local police database. So it's not the police national computer, but there is a linkage between the various local police databases. It's called the police national database. And if another police force was to receive a request for an enhanced criminal records check, and they would then search the police national database, and they would receive an alert saying Humberside, in this case, have a record which may be of interest. It won't tell them what the record is. Say, Humberside have a record, and there is then a protocol for information sharing and safeguards on information sharing as between different forces. But, my lady,
The judge didn't accept the evidence that your witnesses gave, that there were no circumstances in which it would turn up on such an exercise, and we're bound by that finding, aren't we? That's paragraph 182. We can't go behind it.
While you're looking at that, could you also look and see what you say at paragraphs 27 and 28 of your skeleton, which is why I asked the question.
I'm sorry, 20...
It's A43, and paragraph 27 and 28 of your replacement skeleton argument.
So, yes, I accept the judge did not accept our submission that there were no circumstances whatsoever in which it was possible to envisage Mr. Miller's record or the record of the incident concerning Mr. Miller. But equally, no suggestion that this would be otherwise than wholly exceptional. So for example, I think an example which was discussed in the court below was if Mr. Miller had applied to be a support worker for transgender children, for example, then it's conceivable that the record would be of sufficient relevance and cogency.
So if you're a member of the public, what do you know about how this is going to work for you?
So, my lady, the broader point in relation to enhanced criminal records checks is that as a result of a series of House of Lords and Supreme Court rulings, there is a rigorous set of safeguards to restrict the circumstances in which local police information will be put on an enhanced criminal records check. We had evidence of that in the court below. We've referred to some of it in our skeleton. A police force which is contemplating including local police information, soft information, as it's often referred to, on an enhanced criminal records check, has to consider the relevance of the information, the cogency of the information, the accuracy of the information, and to do so against the background of a proportionality balancing test. And there are safeguards including the making of representations by the individual as to whether particular information is sufficiently relevant.
But that depends on the decision whether or not they should be given the opportunity to make representation.
There is it's not an automatic right in every case.
And individuals aren't told, in the normal way, they're not told that an incident has been recorded, a non-hate crime incident has been recorded.
So if an incident has simply been categorised and nothing further has been done, then yes, it is unlikely that will come to the individual's attention. But that would be the fact that an individual didn't know about the record, or probably didn't know about the record and hadn't had an opportunity to give their side of the story. That is precisely the sort of factor which is considered and must be considered by the police before including a record such as that on an enhanced criminal records check. So in terms of the accuracy and cogency of a record, the fact that an incident has been categorised as a hate incident without further investigation or findings, that is highly relevant to cogency and accuracy.
Well, is it? If you're right, and all this is recording of the fact that of this incident, then that is the objective fact is that somebody has perceived this as a hate incident, and that answers the question of cogency. That is the perception. What more is there to investigate?
Well, Milady, yes, it is a record of a perception, but there's a lot more to investigate potentially in terms of putting the allegation to the individual who's being accused of that motivation, of further looking into the circumstances and the context. And if that hasn't been done prior to any once a record has been made, then that is highly relevant to, for example, the making of representations before there's disclosure on an enhanced criminal records check. And can I in this, notwithstanding the judge's finding that he couldn't completely rule out, as we invited him to, couldn't completely rule out Mr. Miller's record turning up on an enhanced criminal records check. And I I should say that the record in that case was a lot more than the mere categorisation, because Humberside did act upon it, and they did make certain findings and took certain steps, and in those circumstances it is perhaps more likely, or where a complaint has been investigated. But in the very limited circumstances, focusing on this case, in the very limited circumstances, such as if Mr. Miller was to apply to work with transgender children, then it may well be considered and rightly considered by a police force that it is relevant information that he makes that complaint had been made in the past of the way in which he described spoke about transgender people. But then that would trigger.
What about an academic or a feminist philosopher who responds to a public consultation expressing concerns about permitting a woman, a transsexual woman, to use a women's refuge? And Ms. B complains about that, perceiving that to be hostile. Would it be right for that concern to be disclosed on an enhanced records check basis when that academic wants to transfer to become a teacher at a school where there are transgender children, perhaps?
Well, there's first of all the question as to whether this would be categorised at all as a hate incident.
Well, if it's perceived by Ms. B to be hostile to transgender women.
Well, subject to the express constraints in the guidance and the rationality constraints which the judge found, which we accept. This type of incident may not be categorised at all.
Well, let's say she says trans women are not women in the context of that debate, which is what Mr. Miller said. And that's one of the things that Ms. B took exception to. She perceived it to be hostile. Let's assume that. That would have been recorded. It was recorded.
Well, lady, in this particular case, the judge he expressed serious concerns to 281 about whether Mr. Miller's communication should have been categorised in this way, and we certainly do share those concerns. We haven't challenged that part of his judgment, and there are a number of Mr. Miller's communications which shouldn't have been regarded.
But he didn't make the declaration
in that way.
We've just been shown that the order that was made.
Well,
so anyway, but back to my lady's question. Assume for the moment that the self-perception, because the guidance doesn't contain a sort of rationality exclusion, so assume for the moment the guidance is followed, the perception of Miss B or Miss X or whoever, in the example my lady puts to you, results in this being recorded.
So, if it is recorded, is the question: should it be disclosed on an enhanced criminal records certificate?
No. The question was: you said it would be right that it should be disclosed because it's a concern that's been raised, and I'm putting to you: is it right that it's disclosed? It's part of a legitimate public debate.
I'm sorry, I didn't say that it was right.
I think you did.
That Mr. Miller's. I said that a police force who had been asked for an enhanced criminal records check in the context of Mr. Miller's application to work with transgender children may rightly consider that is something which is disclosable.
Yes.
Then there are safeguards, for example, the making of representations, and there are protocols, and there is a very detailed proportionality balancing analysis which has to be gone through. And I'm not, and my clients aren't in the position of saying what should happen or shouldn't happen as a result of those considerations in individual cases. But at least the question would be raised in those highly exceptional circumstances. In real life, Mr. Miller's not going to be applying to work with transgender children.
Well, how do you know?
Well,
You might have a career change. I mean,
But an academic might. It's quite possible for academics and people who think deeply about these issues to express views of this kind and be working with transgender young people, children.
yes, it is theoretically possible in Mr. Miller's case, and it is, of course, possible in the example my lady gives. Insofar as if we proceed on the basis that a categorization has been made in relation to the academic who says transgender women aren't women, I have to say that I believe my clients would support categorization simply for that reason. But let's assume there was categorization. Would it be disclosed on an enhanced criminal record certificate? Well, it may or may not be, but there is a detailed process of safeguards which have to be gone through before local police information is disclosed in that way, and the limitations in terms of the accuracy and cogency and force of that kind of information would be highly relevant to the decision of the police force whether to disclose or not. Lady, I'm afraid I can't recall if I've answered your question or not.
Well, I think you've probably answered enough questions for the time being, so why don't you carry on with your submissions?
Well, in the context of the submissions I'd be making, can I just take you to 275 of the supplementary bundle? Now, this is the new guidance. So at the time of the hearing before the administrative courts, the college was consulting on and had produced a draft of new guidance. I think a draft came out very shortly before the hearing. The guidance which was under challenge is under challenge in these proceedings has now been replaced, and this is the new guidance, or this is an aspect of the new guidance. And I was a number of the questions I've been asked have touched on the purposes of categorising incidents as hate incidents, and there are four purposes here. When an incident is reported to the police, it's often not clear whether a crime has been committed. A record will be made to support initial investigative actions and to record any decisions. The second is a recording information for intelligence purposes to identify patterns of behaviour, incident hotspots, etc. Behaviour that falls short of criminal conduct could later be evidence of a course of criminal conduct, e.g. harassment, or as evidence of motivated hostility in a future hate crime. And statistical analysis is the fourth purpose. One of the points raised by my lady, the President, earlier in submissions this morning was well, why couldn't you make a record of Ms B's complaint without saying who she was complaining against, without including Mr Miller's name on the record? And the answer is that you couldn't do that, or you couldn't do that without undermining at least two of the four purposes, that's the first and the third, two of the four purposes of categorising incidents in this way.
But if there's no evidence of hate at all, you can record it based on perception. Is that going to be particularly useful in either the harassment type case or the situation where you're not clear whether a crime has been committed? Those are the two purposes I assume you're referring to.
Yes. So, Melody, what this is telling the police to do is to categorise an incident in a particular way. The first purpose, and then the first purpose, the categorisation will then support, or the record and the categorisation will support further investigation. Now you say, well, what if there's no evidence of hostility? Well, I mean, first of all, there should be some rational basis for the record being made, as the judge found.
And where do we find that in the guidance?
Well, Milady, there isn't an express provision of the guidance to that effect, but the way that it works in our submission is that there are certain, this is in the old guidance, there are certain provisions of the old guidance, 1.2.4, 1.2.5, example, which indicate that not all complaints should be categorised based on perception, and we say, and the judge agreed, that the guidance does not suspend the normal public law constraints which would apply to police actions. It doesn't purport to instruct police, I think as the judge put it, to leave common sense out of account. But in legal terms, it doesn't instruct police that the normal public law rationality constraints on their actions don't apply. It's not intended to be a comprehensive manual for police conduct, and the general law, we say plainly, still applies.
But they're told expressly to record regardless of whether there is any evidence to identify the hate element.
Yes.
So where does rationality come into that?
So regardless, so what the judge found that meant was that the complainant should not be pressed themselves to provide evidence of why they thought that there was hostility or prejudice, and that's the thinking behind that is the importance of avoiding secondary victimisation. But that's not to say, and again, this is what the judge found, that's not to say that that the circumstances may not indicate that there is simply no basis for the record being made, and he gave a specific example of where he thought that it wouldn't be appropriate, really on the basis of the general law, it wouldn't be appropriate to record.
So, Couple, you took us to the new guidance. Could you help us with the previous page, the introduction?
Yes.
Because it says at the beginning there, major investigation, not every reported incident is a crime. If officers are unsure whether a reported incident amounts to a crime, an initial investigation should be undertaken to establish the facts to determine whether it is a hate crime or a non-crime hate incident.
Yes.
When it's established that an offence has not taken place, it should then be recorded as a non-hate crime incident. Isn't that exactly Mr. Wise's point, that at the start you've got to investigate in order to determine whether it's an incident or a crime? But the Humberside approach is to record it straight away as an incident without any investigation.
Yes. So, well, I believe what's being said here is that there will be some complaints which are in the grey area between crime and not crime, and because in that grey area there may be a crime, the police should investigate to see whether a crime has occurred. But there will also be incidents, complaints made and incidents recorded which are not crimes and which the police can take the view immediately are not crimes, and the guidance is not telling them to investigate all of those as well. They may do so, they may wish to do so, but they aren't being told to.
So you're better off if the complaint against you might be a crime, because then you'll get an investigation and it might be that it's not recorded at all.
Well, no. If it's
in the grey area.
Well, if it's in the grey area,
Yeah.
it's investigated and it's not a crime
Or a hate incident.
Then it should be.
Well, but it might be that because they've had to investigate it, they may decide there's no evidence of hate. This person does perceive hate, but it's irrational, and so they won't record it at all. So you're better off the more serious it is.
Well, but if there is an investigation, then yes.
But I thought you said there would be an investigation. There must be an investigation if you're in the grey area.
Well, that is what that is what the first paragraph says.
Yeah.
If officers are unsure whether a reported incident amounts to a crime, an initial investigation should be undertaken. So if an investigation, if we're in this category and an investigation does take place, then yes, the outcome of that investigation may be that the flag, the categorisation is removed. If there is no investigation in the situation you put to me, then all that you have on the file, and it may simply be useful for intelligence purposes, all that you have on the file is a complaint that a hate incident had occurred, which has been flagged, but no investigation, no findings, and has the consequences which are consonant with that. No judgment, no official endorsement of the complainant's version of events, and that will all be highly relevant to what might be done with the categorisation in the future. So the new guidance begins on page 258 of the supplementary bundle. At 260, at the bottom of the page, we have the principle of perception-based recording. And not much has changed. The language around there being no need for evidence is it has been modified. So you see that in the third line on 261, the victim does not have to justify or provide evidence of their belief for the purposes of reporting. and police officers or staff should not directly challenge this perception.
I'm sorry, where are you reading
I'm
from?
261 in the
Yes.
third line.
To avoid me having to do this, perhaps somebody could tell me or produce a document demonstrating what the differences are between the two documents, if it hasn't already been done, because
Yes.
otherwise it's fiddly.
It is, yes. Yes. And perception-based recording will help to reduce under-recording, highlight the hate element, and improve understanding about hate-motivated offending. All allegations of hate crime will be subject to investigation to identify and, where available, gather evidence to demonstrate the hostility element and support a prosecution. Where supporting evidence is not found, the crime will not be charged or prosecuted as a hate crime, and so forth. And then the next paragraph is the equivalent of, I think, 2.5 from the previous guidance. And one does, in my submission, have to bear in mind that although we're dealing with a particular set of facts in Mr. Miller's claim, perception-based recording has a long history since the Macpherson report, is endorsed, as the judge pointed out and as we've explained in our skeleton, is endorsed at European level. And there are very good reasons for it. Now, of course, and as we have seen in this particular case, that we're at the margins and hard questions can arise. But this is guidance which deals across the board with racist incidents, homophobic incidents, anti-disabled, prejudice, and so forth. And in terms of proportionality, it is in my submission important to bear that in mind and to look, as we will in due course, at the reasons and the good reasons for perception-based recording. I think I finished the introduction to my submissions. Actually, while I'm on the new guidance, I'll just draw your attention to a couple of additional passages. 271 going over to 272. There is material which has been included in the light of the first instance judgment. Again, it reflects one of the provisions of the earlier guidance, but there's a specific reference to Article 10 rights at the bottom of the page, and going over the page, a reference to Miller and a link to the Miller judgment. We've looked at 273. 274 in terms of contact strategy also has been modified in the light of the conduct of Humberside in this case. So some changes have been made to emphasise the constraints on police action and the consequences for a person who is complained against, which we say strengthen the proportionality of guidance. So can I then turn to the common law complaints? The legal basis for the guidance is the common law. Police have long established common law powers to record information for policing purposes, and indeed to categorise the information that they have recorded. The College of Policing, my client, has a common law power to issue, at the instigation of the Home Secretary, guidance to police forces as to how they exercise their common law powers to collect and record information. Any action taken by the police to record and retain information is regulated by the Data Protection Act, now the Data Protection Act 2018. That's not the origin of the power to collect and record, but it is central to the way in which police information powers are exercised. I wanted then to refer the court to the CAT judgment in the Supreme Court, which I think you have separately from the authorities, or it may have been included in your bundles, but if it has, I'm afraid I don't. Do you have it separately, or do you have it in your bundles? You may have put it in to your bundle at 9:45.
Might be tab 23K.
Yeah, I put it on the back of mine.
Do you have it?
Yes, back of bundle 4.
So this was, as what will be aware, a case, in fact, two cases which went to the Supreme Court. One of which went on to Strasbourg, Mr. Catt's case, and the Strasbourg court disagreed with the Supreme Court on a narrow issue around the periods of retention for data in Mr. Catt's case. Mr. Catt's case was concerned, you see from the first page from the head note, was concerned with the recording of information about him on a domestic extremism database as a result of his participation in demonstrations. So he exercised his Article 10 rights. And the second case, going over the page, the second case of T was about the Metropolitan Police having issued the claimant with a warning letter informing her that an allegation of harassment had been made against her. And the allegation of harassment was that she had made a homophobic comment to one of her neighbours. So it's not dissimilar to the facts of the present case in that sense. And the letter was issued to her without her having been spoken to first, without her having given her side of the story. The most relevant part of the judgments in my submission concerns the common law powers of the police and the prescribed by law criterion. And if I could ask you to go to paragraph 6 in Lord Sumption's judgment, you'll see that this the ruling was premised on a finding that the state's systematic collection and storage in retrievable form, even of public information about an individual, is an interference with private life. So need to go on to consider Article 8.2. And the domestic legal framework, paragraph 7, at common law, the police have the power to obtain and store information for policing purposes, i.e. broadly speaking for the maintenance of public order and the prevention and detection of crime. These powers do not authorise intrusive methods of obtaining information such as entry on private property or acts other than arrest under common law powers which would constitute an assault, but they were amply sufficient to authorise the obtaining and storage of the kind of public information in question on these appeals. And then in paragraph 8, Lord Sumption outlines the then regime under the Data Protection Act 1998. It's now the 2018 Act, but in substance the same provisions have been carried through and the same safeguards. And then paragraph 9, the DPA provisions are supplemented in the case of the police by published administrative codes, and in particular the Code of Practice on the Management of Police Information. And he goes into detail on what the Code of Practice provides for paragraphs 9, paragraphs 10.
And is it still the same code of practice?
Yes. It may have been updated since then, but it's the same document. In accordance with the law on paragraph 11 onwards, Lord Sumption sets out familiar principles as to the exercise of power by public officials being governed by clear and publicly accessible rules of law, and so forth. And on page 1083 at letter B, for this purpose, the rules need not be statutory, provided they operate within a framework of law and there are effective means of enforcing them. Their application, including the manner in which any discretion will be exercised, should be reasonably predictable, if necessary with the assistance of expert advice. And then in paragraph 12, he summarises the law which he has regard to in accordance with the law, and the DPA safeguards. He notes there are discretionary elements in the statutory scheme, paragraph 13, but their ambit is limited. Paragraph 14, much of the argument advanced on behalf of Mr. Catt and Ms. T on this point amounts to a complaint that this material did not enable them to know precisely what data would be obtained and stored and for how long. These arguments are not, in my opinion, realistic. The infinite variety of situations in which issues of compliance may arise and the inevitable element of judgment involved in assessing them make complete codification impossible. However, any person who thinks the police may hold personal information about him may call for access to it under Section 7 of the then DPA. Towards the bottom of paragraph 15, distinguishing the Catt and T cases from previous authority, he says at letter F, there has been no disclosure to third parties and the prospect of future disclosure is limited by comprehensive restrictions. It is limited to policing purposes and is subject to an internal proportionality review and the review by the Information Commissioner and the courts. And that extends, he's talking in part about the possibility of future disclosure on enhanced criminal records check. Comprehensive restrictions. And his conclusion is at paragraph 17, in my opinion, the retention of data in police information systems in the UK is in accordance with the law. The real question is whether the interference with Article 8 rights was proportionate. And I will be submitting in due course that precisely the same analysis applies to categorization of information collected by the police as it does to retention of that information.
But in Catt's case, there was the objective fact of his presence at a public demonstration that was being recorded, was it not?
Yes, and the fact that he was there, and as were other people who were of interest.
Is the situation here different? What is the objective fact here?
Well, my lord, so far in the judgment I've been looking at in accordance with the law, and for that purpose, there's no difference at all between this case and CAT, because what we're concerned with in this case is the categorization of information recorded by the police. In CAT, it's retention of information recorded by the police. In both cases, the underlying legal basis is the police's common law powers, the Data Protection Act, the Information Commissioner, and the whole range of codes of practice and so forth. And those apply in precisely the same way to our issue as they did to the issue in CAT.
In CAT, whether I don't know how it had worked itself out in the lower courts, but certainly by the time it got to the Supreme Court, there was no issue about interference with the Article 8 right.
That's right.
So, but in this case, you support the judge's finding that there is no interference with the Article 10 right.
With the Article 10 right, yes. If this case had been put on the basis that merely collecting and recording Mr. Miller's information on a police database was a breach of Article 8.1, then, or an interference with Article 8.1 rights, then I couldn't dispute that on the basis of CAT. But this is a freedom of expression case, and
but we've jumped over the hurdle of interference into the issue of the issues that are raised here.
Yes, and I'm coming back to interference, right. but CAT is relevant to common law powers and to so I thought it convenient to deal with it now, but I do have submissions to make about interference. The findings of law assumption between paragraph 32 and 33 on proportionality of retention of Mr. Catt's data, that was the point on which the Strasbourg court disagreed and held that there were insufficient safeguards regarding the deletion of his data after a period. As for T, again, no difficulty with the recording of the information and the issue of the harassment letter. So I'm at paragraph 42 and 43, but the issue was retention. And the benefits of recording information, such as in relation to the allegation of harassment against T, those are described cogently by Baroness Hale in paragraph 54. And she says she agrees with Lord Toulson there are often very good reasons for making and keeping records of incidents such as these. It's not just that, if found to have occurred and to have been repeated within a short enough period for the incidents to be connected, it can form part of a course of conduct, purposes of the Protection from Harassment Act. And it must be recalled that many harassment cases are a great deal more serious than this, if this happened at all. It's also that, particularly in disputes between neighbours and in cases of domestic ill treatment and abuse, the police response to a new complaint will be affected by knowing whether other complaints have been made in the past against the same person, as well known that for a variety of reasons, complaints of domestic violence are often not followed through to prosecution and conviction, but it's vital for the police when responding to any new complaint to know whether there have been similar complaints in the past. Now that's in the particular context of she's particularly concerned.
Well, and it's a long way from this type of case, which is the point that Lord Sumption made in paragraph 43.
Well, lady, you say this type of case. We're concerned with the guidance. And the guide
with T, the case of T, paragraph 43.
Yes. Yes, but even Lord Sumption doesn't think that there's a problem with recording this information. He says the real problem at letter G is that the period of retention seems to be a standard period which applies regardless of the nature of the incident, regardless of any continuing value that the material may have for policing purposes. But the reason I took you to what Baroness Hale said is that you could easily in our submission read across the considerations that she was emphasising to the justification for perception-based recording, or some of the justifications for perception-based recording in the guidance. It may be relevant to future police action to know that a complaint has been made, even if not investigated at the time.
It just seems to be, there's such a fundamental difference between people who know each other or live side by side, where perceptions of hostility emerge, and communications across the internet that are received by people that the individual doesn't even know exist.
Yeah.
And the possibility of that escalating into a course of conduct of harassment, or, I mean, it just seems unreal.
And that's the fact that it was on the internet and Ms. B had never met Mr. Miller and it wasn't directed at her and so forth. Well, that's 1.2.4 of the guidance. That's what the judge focused on in
Not how the police interpreted it.
Well, Melody, I'm not defending the Humberside police. They acted unlawfully, and there's no appeal against that.
Well, and the judge said it was recordable, ultimately.
Well, the judge had considerable doubts as to whether the information was properly recordable under the guidance, 281 onwards. He held, and you saw the order, he held that it was not a breach of freedom of expression to record, to categorise the complaint in the way that it was done. I think the order said the mere recording, and that I submit that was absolutely right, and you know, one can say quite fairly that perhaps this not ought to have been recorded at all, but it's not a breach of freedom of expression when you look at, and I'm coming on to this, when you look at what are the consequences of categorisation for an individual who is complained about. I'm coming on to that in a few moments. So 1.2.4 of the old guidance does, and it's carried through in the new guidance, does address the difference between an insult across the internet and one between neighbours. So the police have established common law powers to collect, record, categorise and retain information. The claimant contends, and this is the first of his specific common law complaints, that paragraph 6.3 of the old guidance is in breach of the principle of legality because, and I refer in particular to the grounds of appeal. I think it's page 11 of the core bundle. The ground is that the impugned provisions of chapter 6, that's 6.3, the judge was wrong to hold that 6.3 was lawful in the absence of express statutory or established common law authorisation. Now, there are a number of problems with the principle of legality submission, but if you just look at the ground, there is established common law authorisation for what the police do, what the guidance asks them to do. That is now very well established, and CAT is the most recent example, and one doesn't really have to go any further than that. But the judge was absolutely right that the principle of legality is a principle of statutory interpretation. He was right because the authorities found him so to hold, and they bind this court as well. And the suggestion that Miller somehow overrules the long line of authority that the judge set out and we've set out in our skeleton argument must be completely wrong. The principle of legality is not discussed in Miller. None of these authorities are referred to, and it cannot sensibly be said to be part of the ratio of Miller that this long line of authority is now not to be followed. That's all I want to say about the principle of legality. The second common law complaint, the second ground of appeal, is directed at the rationality of perception-based recording. And the target, as it were, is as explained by the judge in paragraph 200 of the judgment, paragraph 6.3. He says, from this, what I take paragraph 6.3 to mean is that it is sufficient to qualify as a non-crime hate incident if the complainant perceives hate to be present, as that term is defined in 1.2, namely as prejudice or hostility on the basis of a protected strand, and that they are not required to be called upon to prove that is in fact the case or to provide evidence that that is so. But he goes on, paragraph 203, it seems to me that this approach does not exclude that there must, on the facts narrated by a complainant, be some rational basis for concluding that there is a hate element. I've said that we accept that and don't seek to challenge it. So that's the...
Well, that's your positive case. You're positively now saying that the guidance includes a requirement for the police to test the rationality.
Yes, for there to be some rational basis. Yes, we haven't sought to challenge the judge's reasoning. And we say that does follow from the general law, and the guidance does not purport to tell police forces that normal rationality constraints on their actions are suspended. So, is this a rational, is perception-based recording, in the sense explained by the judge, a rational principle on which to base this aspect of the guidance. And it's our skeleton, paragraph 53 onwards. The various materials were set out in detail in the judgment below, and I'm not going to go to all of them, but the origins are in the Macpherson report, paragraph 53. Paragraph 54, the recommendations of the Macpherson report being adopted by the Home Secretary. You have that in the supplementary bundle. Since its adoption following the Lawrence inquiry, perception-based recording has been an important part of the policing of hate incidents over the past 20 years, including through the cross-government hate crime programme and its consultation with the Independent Advisory Group on Hate Crime. And then the IAG is described. Paragraph 55, the adoption at European level of perception-based approach. Again, you have that at 257. Perhaps I can just show you that at 257 of the supplementary bundle. This is a Council of Europe body called the European Commission Against Racism and Intolerance, and it's a recommendation that begins at 254 on combating racism and racial discrimination in policing, and at 257 one of their recommendations is set out, and that a racist incident shall be any incident which is perceived to be racist by the victim or any other person. The recommendation provides that a racist incident be defined as an incident which is perceived to be racist by the victim or any other person. The adoption of such a broad definition of a racist incident has the advantage of sending the message to the victims that their voice will be heard. The definition is drawn from the Macpherson report.
That's just in relation to race.
Yes.
And do you see any difference between race, perception-based reporting in relation to race, and perception-based reporting in relation to transgender?
No, we don't see a difference, and the guidance applies the same approach, as you know, to the different strands on the advice and with the agreement of the Independent Advisory Group on hate crime. Now, of course, how the guidance falls to be applied.
Do you have anywhere, I'm sorry, do you have anywhere, I know we've got witness statements from some of the members, 3 I think. 4, is it 4? Do we have a list of the membership of that group?
We will provide you with a list of the current members. I don't think it's in the papers, but we'll provide that. Yes, but paragraph 50. Yes, I think I was saying in answer to my lady Justice Simler that how the guidance falls to be applied, of course, may well differ from strand to strand, but the guidance at a high level is laying down principles which we say are equally applicable to the different types of hate crime and hate incident. Yeah, so 56, four eminent members of the IAG had given witness statements as Mr. Ainsworth, Mr. Angel, Mr. Hall, and Mr. Wine. And then paragraph 57, we've summarised the objectives of recording on the basis of complainant perception, drawing on the evidence, ensures police do not involve themselves in debate over what is hate and what is not, which could lead to divergent outcomes depending on the views of a particular police officer, avoid secondary victimisation categorization. And we quote from Mr. Antjul in the LGBT context. C, the volume of messages which constitute hate incidents is often so large that it would be impossible in practice for police to investigate and make decisions on the motives of each one for deciding whether to record or categorise the incident. And the recording of non-crime hate incidents on the basis of perception ensures these incidents can continue to be monitored intelligence purposes in a practical manner. And then D, another important practical consideration, that the victim, the complainant in an incident, has first-hand experience of what was said and demonstrated at their time, and based on their particular identity, will have a strong sense of whether they were targeted because of a protected characteristic. Again, we quoted from the evidence of the experts on that. So perception-based recording, in principle, we say has a long and distinguished history now, serves important purposes, is not irrational. Of course, it should have constraints and does have constraints, but it's not in principle irrational.
Can I just ask you about secondary victimisation? I mean, obviously this is a tricky area, but I see at B, secondary victimisation where a negative response given by an authority to a complaint results in the victim suffering further harm, including as a result of denial of the perpetrator's motive. I mean, the implication of that is that a positive response is being given which validates the victim's response, because otherwise it's, I mean, that's, in other words, it gives the victim, as called here, the impression that their voice is being heard, something's happening, this is being taken seriously. It rather goes against the suggestion that this is a sort of neutral, simply a neutral record, because otherwise it's not really doing what it suggested there is being done to the victim. The impression is being given to the victim. It's being taken seriously. Hear what you say. You say that, therefore it's so.
Well, it's not. If you say that, then it is so. If you say that you perceived an incident to be motivated by hostility or prejudice towards you on grounds of a protected characteristic, then we are not going to challenge you to provide evidence of that. We're going to categorise the incident accordingly, and we may investigate and take further action, or we may not. But it very much is not saying just because the complainant says that there was hate that the police must therefore find that there was hate. It's saying the police should flag this incident within that category. Whether it is in fact a hate incident may be investigated, may be so, it may not be so, or it may simply lie on the file as a complaint of a hate incident.
And just how long does it lie on the file as a hate incident without being investigated?
So, Lily, this is perhaps an important issue which hasn't, I don't think, been explored in the evidence and arguments in this case. I can give you an answer at at a high level, which is that the Code of Practice on Management of Police Information provides for, requires regular reviews of data held by the police. I can't tell you the period between reviews, and it may differ from force to force as to what exactly they do. But what police forces are supposed to have is a regular programme of weeding of records, depending on how useful they're likely to be. I'll check and see what the Code of Practice says about that. Of course, that was the issue in CAT and T is how it's not the recording. One can understand why these things are recorded, but how long do you keep it for? And that is regulated ultimately by the Data Protection Act, but there is a specific Code of Practice. So, just finally on rationality, as the current law stands before this course has made its ruling, as the current law stands, the guidance has been held by the judge to incorporate or not to exclude the normal rationality constraints which would apply to police actions, and as I said, we accept that. It's a little unclear to us why that is now being challenged by the claimant. It seems that the claimant wants paragraph 6.3 to be quashed because it doesn't contain the rationality constraint which the judge said it does contain. But then that would leave it open to my clients to reissue paragraph 6.3 with an express rationality constraint which the judge found was already there. So it's hard to understand what the point of this particular complaint is. There are rationality constraints as found by the judge. Both parties agree that there should be, and that the judge was, at least in substance, right to find that there were. Article 10, interference. We say that the judge's findings of no interference with Article 10.1 rights were entirely justified when it is borne in mind how limited is the effect that the challenged provision of the guidance actually has. So, I'm going to go back to my introductory remarks. The guidance, paragraph 6.3, does not mandate the recording of an incident. It does not in and of itself mandate the recording of an incident. That is the NSIR. And the NSIR also has the list of flags, categories, or qualifiers, including hate.
To what extent should we look at them separately, as my lord pointed out? They are mirror images of each other, relevant parts, and...
Well, the part of the NSIR that I rely upon is the previous page to the one that my lord was showing me, which is the general principle. This is what an incident is. This is what should be recorded. Now that's before one gets to applying categories and hate and so forth. My point is simply that Ms. B's complaint, in this case, would have been recorded regardless of this guidance.
But not as a hate incident with somebody referred to potentially by a police force interpreting it in that way as a suspect.
So, absolutely, what the guidance does is to tell police when they should apply a categorisation, when they should apply the categorisation to an incident they have recorded in any event, as a hate incident. Yes, it does tell them that. They aren't told by the guidance to do it on the same template as the crime.
But they are told to record it. 6.3 uses mandatory language.
Well, Milady, they're told to record it as a hate incident, but they are recording it because of the NSIR. If 6.3 didn't exist, Ms. B's complaint is still recorded.
But it would just be recorded as a complaint.
But not as a
rang up and complained, and that would be that.
I'm sorry, I'm not disagreeing. It is my argument that what the guidance does is to tell police when to apply the hate categorization.
And doesn't that potentially stigmatize a group of people who are engaged in a public debate about these issues, who are more likely to be complained about by people like Ms. B or others who feel offended by this debate? And doesn't it have a chilling effect, therefore, on their freedom of expression? And that's the interference.
So, Milady, you're understandably focusing on the particular facts of this case. On these particular facts, the judge found that there are very serious concerns as to whether this information should have been recorded at all, or whether the hate categorization should have been applied pursuant to the guidance. That's 281 onwards. And again, we're not challenging that. So far as looking at the guidance as it has to be viewed for the challenge that remains, is across the piece. Is it an interference to record, to categorise an incident as a hate incident? Well, let's take it in stages. It is the categorisation which is the proper complaint about the guidance. The meaning and effect of the categorisation is not, as I've been submitting, that the incident was in fact motivated by hate. It is that is what the perception of the complainant was. So you talk about stigma. Well, if as Mr. Wise submits, the police were saying, well, yes, Ms. B said that there was hate, and therefore there was. If that was what was being done, then there might be some force in this. But that's not it. When you understand the principle of perception-based recording, the mere categorisation is, and for all the reasons you've seen why it's done, the mere categorisation is not a stigmatisation of.
Well, how far can you take that? Let's link it to the rationality argument for a moment, which involves the proposition that there has to be some rational basis to categorise it as a hate incident. On the one hand, you're saying it's a neutral recording and no more, but you're accepting that there has to be a rational basis for it.
Yes.
So the question is that stigma-free in circumstances such as that? Because it connotes the acceptance by the police that there is a rational basis for somebody saying that there is a hate element in this tweet, speech, or academic paper.
Yeah. Well, and there may not be a rational basis. But yes, if there is, if an incident is recorded, that does connote, or should connote, that there was some rational basis for the perception. But that is not, in my submission, stigma. That is not in my submission equivalent to a judgment being made. And the further point, the very important point, is the categorisation in itself goes nowhere. The categorisation is useful for the police for certain purposes, and you've seen the purposes. But in and of itself, it doesn't stigmatise or interfere with the actions of the person complained about at all.
Well, is that right? I mean, isn't the whole purpose, you said, of this information to have something there for the next time a complaint is made? I mean, if Mr. Miller or one of the academics or a speechwriter does it again and a different person complains, the police will have been an earlier complaint, and that might then lead the police to think, well, this is something that we need to take further and investigate, whereas if there hadn't been such a record, nothing would have been done.
So they might do, or they might take the view that 2 times 0 is 0 and not. But, lady, if they do take action in relation to the person complained about, it is that action, it is the investigation, the sort of things that Humberside did in this case. It is that which would have to provide the basis for the interference.
But that's what creates a chilling effect. It's that risk. It's the risk that if I speak out on an issue like this, I might be complained about once or twice or 3 times, and then the police might take some action against me.
So, but one has to remember, the guidance is about categorising a record which is going to be made in any event as a hate incident. You could be complained about on 2 occasions, and on the second occasion, the police type in your name into the database. Oh, and there's a record of a complaint against you. It hasn't been flagged as a hate complaint, but let's look at what it was. The effect that you're referring to is simply the effect of the police keeping records. There's no additional stigmatization or additional, simply because the records are ordered and flagged in a way which has been found to be useful.
But in terms of Article 10, I mean, we talk about perception-based and the importance of perception-based recording for this purpose, but there's an important perception of the person who's being recorded to, in terms of the chilling effect.
Really, so there's been discussion about the chilling effect. Can we in either evidence or in authority? And on the latter point, there is no authority anywhere near this case in terms of the magnitude, the very limited magnitude of the interference which is being complained about. Once you understand that it is categorization, it's not recording, it's categorization, there is nothing in the authorities that comes within a country mile of this as an interference. The claimant had various authorities, some of which are referred to in the judgment, about administrative penalties, about criminal sanctions, about actual interferences, although some of which weren't on their facts interferences. There is nothing that is anywhere near this case in the authorities. Now, that isn't a complete answer, but in terms of what Strasbourg regards, what our courts regard as an interference with freedom of expression, categorization, as in this case, there's nothing like it at all in my submission.
But let's just look at this and put aside what we're talking about there, what authority there is. I mean, if the fact is that people know about this type of recording and it has an impact on what they feel they can and can't safely say, what then? Are you saying that that is, which is after all the evidence that was put before the court below in relation to Mr. Miller and his family. What are we to make of that?
So, Lady, the evidence which was put forward by Mr. Miller and his family did not correctly identify my submission what the guidance actually does. The evidence of Mr. Miller's wife that you were shown yesterday was focused on the approach to her daughter, which of course was wholly inappropriate, and we don't condone that. Mr. Miller's case below was premised on the effect of the guidance being that Ms. B's complaint was recorded.
But if we know that records are being kept of what we're saying about things, you're saying it wouldn't cause us to moderate our behaviour in certain ways, just as an ordinary piece of common sense, if we're allowed to use that phrase here.
Lady, the first point is that it is not the guidance which mandates the keeping of the record. That is the NSIR. If the guidance did not exist, Ms. B's complaint would have been recorded.
But if the guidance mandates, my lady's pointed out, the keeping of a record of it as a hate incident. With the implications for people being described as the author of hate speech, as we know from what occurs in the real world, are very significant.
So, my lady, one then asks, well, what are the implications of this categorization? That is the question. Once you've identified that the mischief here, what the guidance adds is a categorization. What are the implications of that?
I see it as. I'm sorry. I see it's 1 o'clock. So.
I'm sorry. Well, I will consider the implications of it.
Now, we've been asking you a lot of questions. How are you getting on in terms of time?
Well,
we're on Article 10.
Yes, I have.
We have the rest of the afternoon.
Oh yeah, well I know I'm certainly well on target for that. I may be another hour, depending on questions.
We'll sit again at 2 o'clock.
All rise.